Kelly Phelps is a legal expert. She joins us now. Kelly, good afternoon to you. I have to confess, it's so strange watching all of this be sort of rerun and to see and hear this witness giving testimony to the person she's given it to before.
Absolutely. You can imagine how much stranger it must feel for her as well. But this isn't unprecedented in terms of the law. Unfortunately, it does happen from time to time that there's a necessity to replace a judge. There have been well-known cases where judges have died partway through a trial. We get applications fairly often for judges to recuse themselves from certain matters once the matters have already started, and information then comes to light that makes the recusal application pertinent, and even sometimes as far down the line as after a successful appeal. So sometimes once a case has been finalized, the trial has been finalized, and it's appealed to the Supreme Court of Appeal, one of the competent findings that can come out of those appeals is, in fact, that there needs to be a retrial. So although it's a very strange thing to witness, it's not entirely strange to the justice system.
All of the witnesses and all of the lawyers know this evidence, but the judge presumably doesn't. I mean, maybe he has a Netflix subscription, maybe he doesn't. Does that put him at a disadvantage in any way?
No, I'd actually say from a legal perspective, it may even put him at an advantage. We know that for legal proceedings, there's very strict rules and procedures as to what evidence can be considered in reaching a verdict and what evidence cannot be considered, and also the relative weighting of various types of evidence. And although we like to laud our judge-led system and say that because it's a professionally led system, it means that bias doesn't make such an impact in our criminal justice system, and, you know, all of the personnel are very well trained, and that's true, but you can't train humanity out of a human. People are still susceptible to being influenced, particularly when cases are very high profile and they're being bombarded by different sources of information all the time. So I would say from a legal perspective, it's actually to the advantage of the judge and certainly to the advantage of the integrity of the case that he's hearing it afresh.
Do you think there'll be a slight difference in the atmosphere of the courtroom when we get a witness who didn't testify the last time? I think it was 5 witnesses who testified the first time. You know, once people learn their lines, Kelly, and I don't mean they're tailoring their evidence, but they kind of know their lines, they rush through them. When we get the sort of 6th witness in this hearing, do you think things will be slightly different?
I would imagine so. I mean, first of all, for someone who hasn't had the chance to essentially test run their evidence, the whole environment of the courtroom is going to be new to them. And that's a very intimidating place to be. So I would think for the witnesses that have already testified once, they've at least got over that first shock factor of the intimidation of being in a courtroom and being part of a legal process. I think, though, what may be different with the witnesses who have testified is cross-examination. And I think it's actually quite difficult for the lawyers doing cross-examination now, because a lot of the tactics that you would use for cross-examination come with the element of surprise. In the case of the witnesses who've already testified and have already been cross-examined, it's going to be a lot harder for the defense lawyers to produce the kind of fresh responses in cross-examination that they may have elicited the first time.
The element of surprise, I mean, as you point to, is very important. It really tests someone's knowledge. You jolt their memory. You put them in a position. I mean, we've all watched, you know, the series that do this. You put them in a situation where there's a question that either they can give only a truthful answer or no answer at all. So could it be that justice actually is not served in this way when you remove that element of surprise?
I mean, it could certainly hinder justice. I think it's a very extreme statement to say before one has seen how this matter plays out, that justice has certainly not been served or has been destroyed. But it's definitely a risk, and it's a bigger risk in a case like this than it would be in any other matter. We know that cross-examination is one of the central pillars of the entire build of the South African criminal justice system. So having a weakened ability to cross-examine a witness is certainly going to be a hurdle for the defense. Having said that, they're going into this very keenly aware of that hurdle, and I have no doubt that they will have spent a lot of time thinking about strategies and ways of approaching the witnesses in a fresh light in order to try and at least minimize the impact of the fact that they don't really have the elements of surprise working in their favor.
So I know lawyers often, well, they tell us they spend their time working through the night during a trial, preparing for next day's testimony. Is it worth their time going through the court record of the last time we heard all of this witness testimony, or is there no point at all?
Oh, no, I think there certainly would be a point. Any time you've got access to any source of information that helps you either better understand the propensities, personalities, and tendencies of a witness before you're going to be examining or cross-examining them, or to get better versed on the substance of the evidence that they're about to give, it would certainly allow you to be better prepared for your own performance in court. So I would think it would be very pertinent to the lawyers.
Kelly Phelps, thank you, the legal analyst. Really do appreciate the time this afternoon. More coverage, of course, of the Senzo Meyiwa murder trial through the evening and tomorrow.